My name is Earl O'Donnell. I'm the co-chair of the Planned Giving program at St. John's. We would like to thank everyone and welcome everyone to this session, which is one of 4. The title is Navigating Life's Changing Seasons, End of Life Planning for You and Your Family, and it's sponsored by Serving Seniors. Joanne Allen is the chair of that, and she would be here today, but for the fact that she's returning from London, and as I understand it, is in the air at this moment. Before I roll into the brief introduction of our speaker, Tom Gentile, I thought maybe we should just go around the room and also online and have people introduce themselves. But before I do that, I see some faces. Are you able to hear? Are the people online able to hear me? If so, just go like this. If you didn't hear me, well, I think that'll be the answer.
I can hear you.
Oh, thank you. All right. So why don't we start at this end, right? And roll around the table, and then we'll go to the folks off on the side.
Hi, I'm Blake Vicente. Thank you so much for coming today. My mom is older than me and doesn't think about these things.
Yes. I'm Denise Galvin. I'm Denise Corrado. Ellen Miles.
Peter Pocky.
Tom Gentile, a lawyer and a old classmate of Earl from BW Law School.
I'm Kathy. Anita O'Reilly.
Scott McNulty.
Jerry Daly. Sarah Reynolds, Associate Director.
And then we have some folks who probably are on the screen. You can be heard. You want to introduce yourself?
Francis Lee.
Laban Healy.
Suzanne Welch.
So again, thank everyone for attending. The Planned Giving program at St. John's was formed a few years ago to encourage people, among other things, encourage people to think about St. John's as they were writing their will or doing other documents such as life insurance and pension plans. And we've had a goodly number of people do so. We honor them every year as members of the Norwood Guild for those that have remembered St. John's and their planned gifts. And then we have Norwood Saints after the person passes away. It's a somewhat permanent memorial to them, and they have provided a bequest to St. John's. One of the central missions, really an important one to me, is that the first step in this process is to encourage people to think about and then do what we all know we need to do, which is to have a plan for our state, for our affairs and future. And it's really hard to put off. So I'm really pleased today that the first part of this 4-part series is focusing on how you go about doing the will, the estate, the documents that deal with disability, all those sort of things, with the help of Tom Gentile, who, as Tom mentioned, was a classmate of mine at GW Law School. We graduated in the last millennium, and we've been friends for almost 50 years, do math. Tom's practice led him into a significant local practice. Much of it focused on estates and trust planning. He has spoken at St. John's before. He has advised St. John's, including Kathy May, on their estate plans. And I think without further ado, I'll just turn it over to you and ask you to lead us.
Thank you, Earl. I think I'll stay seated because I got to work the PowerPoint here, so it's easier for me. But if anybody has any problems hearing me.
Oh, 1 second. I neglected to ask people online to introduce themselves.
Yeah, let's try again. Shall I just go around this Zoom room?
Yeah.
Rosemary, would you start, please? I'm gonna have to unmute everybody.
I'm Rosemary Fonseca.
Nadia,
I'm Nadia Carroll.
Christina Frank,
Hi, Frank Curdo, long-term parishioner.
awesome. I see Susan,
Susan Bradley.
and Fred,
You have to unmute.
Hi, Fred Ordway.
see another Susan. Maybe Sawan,
Sawan Bestman, parishioner.
welcome. I see
Thank you.
Pat. And I see Stephanie.
Yeah, Stephanie Clipper. I've been at St. John's a few years now.
Welcome, Stephanie. And then I see 534395. Not sure who that is. Well, welcome, everybody. And Tom, thanks. That's
Do I need to unmute my microphone?
You don't.
Okay, so you can hear me, everyone, right?
Can everyone online hear?
Yes.
Okay, great.
Yes.
Okay, thanks for having me here. Think of this as estate planning or wills 101, and not an advanced course, but sort of a basic course. And feel free to stop me if you have any questions, and I guess you can submit questions if you're remote. Now, when we talk about wills and estates, one basic question I always get is, do I need a will? Should I have a will? The answer probably in most cases is yes, but believe it or not, in some cases it might be, it's not really necessary, but ordinarily it is the case. I like to tell my students that there's only two ways to die. We thought there were a lot of ways to die, but as far as estate planning is concerned, there's only two ways to die. You could die testate or intestate, which means you die having left a will or dying not having left a will. So that's why we call it testate with a will, intestate not. Many people have situations where they have taken their property and they have it in a joint name with a spouse or children, and or they have some sort of designation on an account which passes the funds in the account to another person when they die, with a spouse and children, could be others. So one thing I like to point out initially is that a will will only take care of property which you have not put into a joint account or have designated somebody. So the banks like to use the term POD or payable on death. Those funds will pass directly to the person you named, and your will cannot change that. Some people think they can, oh, I designated my daughter as payable on death 20 years ago, but now I want to give my funds to all the other children in the family, so I'll just put that in the will. That's not sufficient. You would have to go back to the bank in that situation to make that correction. The will would not cover that. Let's see if I can share my screen here. Put some slides. All right, how about this? All right, can you see that? Yeah. Okay, if a person dies having left a will, his or her property that was owned solely, not with another person, as I just mentioned, will be distributed according to his or her will. If a person dies not having left a will, dies intestate, as we say, his or her property that is owned solely, not with another person, will be distributed according to state law, typically to spouse, children, parents, siblings. In Maryland, it's they have a typical intestate statute. So if you die without a will, the property goes to your spouse, children, part to your spouse, part to your children. If you don't have spouse or children, it would go to your parents, actually. You don't have, your parents are not living, it would go to your brothers and sisters. And it's a long line. There's about 8 or 9 because aunts, uncles, cousins, and so on. So it's a pretty long list of people that your property would be distributed. A lot of people say, well, if you die without a will, it all goes to the state. That's not true. You'd have to be pretty much without any relatives. But believe me, I have confronted that situation where the property is cheated to the state. If a person dies having owned property jointly with another person as a joint tenant, his or her interest in the property will automatically transfer to the joint owner. The will does not apply. The most typical situation is probably your residence. If you have it with a spouse, it will transfer directly to the surviving spouse. You don't have to worry about wills and probate for that type of. Okay, so with wills, we're talking about property that's owned solely. Now, a lot of married couples, for example, would have wills. And the idea being that, you know, when the first person dies, first spouse dies, the property will all go to the surviving spouse. And he or she has a will, which then distributes to children, charities, as the case may be. A lot of times you'll see that married couples will have very similar looking wills because you really don't know who's going to die first. So you pass it to the surviving spouse first and then along to your whoever your beneficiary might be. Let's see. Okay, yeah, payable on death account. So I mentioned these earlier as well. If a person places a beneficiary on his or her financial account or designates the account as payable on death to a certain person, those funds will be transferred on death to the named persons. The will cannot change that designation. Any change must be done with the bank, a financial institution. Naming a beneficiary on death is typical for bank accounts, stock accounts, and retirement accounts. The funds go directly to the named person without probate. Particularly with retirement accounts, it is a very good idea to name a beneficiary. It's quite complicated if the retirement account, like an IRA or a 401k plan, goes to your estate. Typically, when you set those up, the person setting up the financial institution will ask you who your beneficiary is. And so it's a very good idea to name children or other persons that, or you can even name a charity. My battery's running low, but I thought I plugged it in. Okay, we're plugged in. So think about that with a retirement account or 401k out, naming an individual. It would go to your estate. It just complicates the matter if your IRA or 401k goes to your estate. It's sort of a complicates the probate. And it also complicates the matter for your ultimate beneficiaries in terms of when they can withdraw from the account. The taxation of the account, for example, if they would take the entire IRA in a lump sum in that particular year, it's all taxed at a regular tax rate, etc. So again, this is Wills 101. So, but keep that in mind that there are special considerations with respect to retirement accounts and 401k plans. Okay, so you might want to do something special about it. Some important items to include in a will I've listed here. Naming a personal representative. The old term is executor. Nearly all the states use the term personal representative now. Means the same thing. Even if you put in your will executor, we know what you mean. We know what you're going to do. This can be a family member or beneficiary of your estate. That's probably typical. In the past, people used to use Well, they might name a lawyer, they might name a financial institution as executor. The lawyers will do it, if they make money that way. But, I think the most difficult situation is if you, certainly a spouse or, a trusted family member is the best way to go.
Can you have two executives?
Yes, you could have 2, 3, 4. Imagine though, if you had 4 or 5 executors, the paperwork and, you're doing all paperwork. So the more executors you have, the more sort of unwieldy probate. 2 is fine. But I've had situations where somebody wants 3 or 4. So here's a situation. A man that died, let's say he's a widower, he has 4 children. He doesn't want to slight any of the children, so he names all 4. It could be unwieldy. Better probably just to name one and, just communicate to the others that for convenience, I just name one of you. Okay. But you can, yes, absolutely. And also in a will, it's very good to name a backup personal representative. So if you name, let's say, daughter A as your personal representative, you'd have, if daughter A is unable to serve for any reason, daughter B would be the backup personal representative. Okay. The banks don't like to do it anymore. The banks don't like to be personal representatives anymore, unless you got a lot of money. I mean, $100 million or something. They just don't want to deal with it, et cetera. So I think it's better just to name a family member. Okay, another put down and make specific requests, desires to individuals or charities. Now we won't get into today about charitable requests and how you might want to leave money to a church or a school or whatever, but this is something you can do in the will. There are also other options that we'll probably discuss at some other time about setting up living trusts for charities and so on. But certainly in your will, you can leave specific requests. In any amount or in percentages, this is something that you really make. I get it from a lot of people. Well, should I leave a specific amount or should I leave a percentage to this institution? And somebody doesn't know really what they'll have when they pass away, so they don't know if that's an adequate amount of percentage or not. So I don't know. You can always change. Wills are not forever. You can always go back and make a codicil, amending will, increasing amount, decreasing amount as you go along. Something to consider. Yeah.
On that, I've heard people just saying, well, I'm going to change the will, and they start striking provisions out and put interlineations in the margins, and then they think they have a modified will.
Not good. Yeah. We're going to talk a little bit in a moment about how wills have to be formally signed and witnessed. The same thing would be with any amendment to the will. You just can't take it out at home, initial it and so on. So you have to sign another document. It's called a codicil, is the amendment to the will. It has to be executed with the same formalities as the will itself. Or you can just rewrite the will and execute that way. But no, you can't just cross that. Okay, after you put your specific request, then we have what is called the residual distribution. Everything else, I've given 10,000 to this church, 10,000 to this school, and so on. What happens to whatever else I have? Well, I want to divide it I want to give it to my 3 children in equal shares. Or perhaps I want to give it to my spouse if she's living, but if she's not living, to my children in 3 equal shares. When you list children and you said that would be an example of a residual distribution. Okay. If there are minor beneficiaries, that is persons under 18 or disabled persons who are beneficiaries, provisions in the will to distribute bequest to a guardian or a trustee. Persons under 18 cannot take property. So you should designate a guardian or trustee of the property do they become of age. frankly, most, I don't know if I did a poll or a statistical count. Most parents probably are not comfortable with that age 18. So you can put in your will that Johnny gets 1/3 of my estate upon him attaining the age of 24, 25, or whatever. There's a lady in Potomac I had whose kids got it when they became 62. But that's a little sweet. Typically it's something in their 20s or whatever. You're thinking 18, 19, maybe he or she doesn't really know how to handle it. So you can certainly put that in the will that they would not get to request until they become a certain age. And in the interim, you would have a trustee. In other words, if they're 20, if they were to be 21 when you pass away, you'd have a trustee to manage those funds until they became, let's say, 25 or whatever age you wanted to. And the trustee, you would set this out in the will, would be empowered to provide funds for their education, healthcare, things of that sort in the interim. And then when they become 25 or whatever age you choose, the funds are turned over to you. So you would set that out in the will. Okay. Will has to be properly executed. They must be signed and witnessed to be valid. There's a saying that a will valid where executed is valid everywhere. So that's probably the case. So even if you move to some other place, yes.
We have a question from Zoom.
Yes.
Can it be set on a condition rather than an age for a minor? For
Yeah.
example, completion of grad school.
Yes. So the trustee would make that determination if Johnny, let's say, has finished graduate school and then he gets it. So yes.
Thank you.
I've had parents who've had children who had problems with sobriety. And they put in the will such things as when in the trustee's determination they've been sober and they're remaining sober, whatever, you can put that sort of language in there. I mean, I wouldn't put down, when the Nationals win the pennant again, or something like that. I put something that's sort of in the control of the benefit. Okay, so wills must be they're on the most of the states, they have to be signed in front of 2 witnesses and who are not beneficiaries of the will. Actually, there's a ruling that a beneficiary could sign, but it's not a good practice because that's not always the rule in every case. Best practice is you sign the will in a room where there are 2 other non-beneficiaries witnesses. It could be the lawyer or somebody else who's a friend down the street, whatever. But 2 witnesses, they sign at the same time. We don't notarize wills in Maryland. Virginia, they do, and they're valid without a notary. How best to say this? It's in Virginia. There's one other state out there, not near here, that has it's customary to notarize wills. It saves paperwork and probate. Let's put it that way. In Maryland, the will goes through. They don't even contact the witnesses unless there's some problem or somebody makes files a lawsuit or something. But Virginia, they do contact the witness, so therefore it's easier to have it notarized. But we just don't do it in Maryland. It's just not done. But there's no harm in it. It's just it's not something you have to do. Okay. Where to keep your will? I get this question a lot. And there's my answer. Other people may have different answers. So there you go. In my view, it's best to keep your will at home in a safe place and to tell your personal representative executive where it is kept. So if you keep it in the refrigerator under the bologna or something in the unit, tell them that. Or if you keep it in the, your copy of The Old Man and the Sea on the bookshelf, tell them that. But tell them where it is so they don't have to tear your house apart. to find the will. Let people know where it is. So keep it a safe place to know. The problem with the safe deposit box, I put up here, is the difficulty of the personal representative. That's the person who's got to get the will if you pass away. The problem is getting it out of the safe deposit box, because the bank's not going to let the personal representative in there until they get appointed personal representative. And the personal representative can't get appointed personal representative until they get the will. And so you have this standoff here. So I don't know, probably not a good idea to keep it in there. A lot of lawyers will keep what I usually do. Some people don't like this, some people don't, but I'm just gonna tell you. I usually have duplicate copies executed, and I keep an original, and I have the client keep an original. And invariably, I get calls saying I can't find the will, and I have it there. So that's one way to do it. If let's say you husband and wife, they have one daughter, and the daughter's going to be the personal representative. She should know where that will is, or even have a duplicate original or something of that. Okay. In Maryland, one of the few states that you can still lodge it with the registered will. You take up the Rockville and put it in an envelope, sign the back of the envelope, and file it there. So most people don't do that because then if you want to, you can take your will to the courthouse in Rockville and file it with the registered will before you die, and they will keep it. I guess a lot of people don't like that because if you're going to change it or amend your will or something or move out of state or whatever, it's an issue. It's a problem.
That would be the same place.
Yeah, that is a safe place, but then if you're going to amend it, it's it's a problem getting it out of there, or if you move to another state and so on and so forth. So I don't know.
Plus, if you died, how, and it was a weekend, how could you ever get a hold of
They
it?
would get there. They would.
Yeah.
Or during that pandemic.
We have another
Yes.
question from Zoom.
Yes.
Is there anything people should know about Maryland wills? And does a person need a Maryland will if they have one from another jurisdiction?
Usually not. Most lawyers won't tell you that. They want to, but as I said, a will valid where executed is valid everywhere. So there's very little differences from state to state. Now, it's always good to ask, though, a lawyer or something if you move to another state. There may be some quirky tax issues based on what you have in the will. So that's a reason. So what I would say is it's certainly not mandatory if you move to another state to change your will, but it's worth asking or just reviewing it, have a half hour, 1 hour consultation with a lawyer just to review that. But it's usually not required to amend it. Okay. But no harm in checking that out. Some people say, "Oh, you got to change your will." No, I'd say 90% of the time, 95% of the time, you're not going to have to change. Death taxes. Speaking of death taxes, that's not a term that the lawyers use, but that's what we throw around. So let's talk about death taxes. Currently, the federal state tax kicks in only when an estate exceeds $13 million. So if you're under 13 million, no state tax. Actually, I think it's 12.98 for this year. I put 13 to round it up, but it's about 50. And that's for marriage. That means 26 million for a married couple. Yeah, I guess it's 12.92. The threshold increases each year. Now, it is possible, I'd say unlikely, that the threshold will decrease. That's going to be up to Congress. Congress could decrease that amount. The current amount actually sunsets at some point. But I think I just read something last week that in this particular Congress, they're going to do something about that. So all I would say is keep an eye on that. It'll be, believe me, it'll be in the newspapers, it'll be all over. But this is something you always do because Congress can change anything the next day. So always keep an eye on this. But what I'm saying is the current amount is 13 million. probably unlikely to decrease, you know. Who's in Congress? There's a lot of wealthy people in Congress. And they're not very likely to just reduce the estate tax. The estate taxes are not popular, even people who never are near to paying it, don't seem to like it, don't seem to like the estate tax. So it's for very wealthy, but all I can tell you now is keep an eye on what Congress does. Right now it's 13. You know, when I started practice some years ago, throughout the 70s, 60s, and 70s, the estate tax limit was $250,000. So you sort of paying the estate tax at that amount, but it's going up gradually over time. More importantly, maybe, is number 2 I have up there. The Maryland estate tax threshold is $5 million. So quite aside from what the federal estate tax threshold is, the Maryland state tax threshold is $5 million. So if you have a state in excess of $5 million, they begin taxing. By the way, both the state and the federal state and Maryland, the exemption is under that. So if your estate is over $5 million, let's say your estate is $6 million in Maryland, you're only going to be paying the state tax on that $1 million. They don't go back again. The rest of it. Same with the feds. If you're over 13 million, the first 13 million is free. It's only the amount over that. Yes.
And that depends where you die.
Yes, where you're not where you die, but where you're resident of. If you're on vacation in Mexico and you're resident of Maryland, then it applies. So it's where you're resident of. Yeah. Yeah.
So the tax comes off the estate before it gets distributed.
Yes. Yes.
So it doesn't matter where the beneficiary is.
Right, correct. Beneficiary, really, the residency of the beneficiary for estate tax purposes have nothing to do. They can be anywhere. So that's paid by we're going to get to inheritance tax in a moment, which is a little different. But on estate tax, it's levied on the estate itself before there's any distribution. Yeah.
You mentioned before that the best practice with the pension plan, for instance, is the designated beneficiary. One of the reasons is it doesn't go through probate
Right.
that way. Right. Is the money in the pension plan included in the estate?
Yeah,
estate
good
tax
point.
purposes?
Good point. When the feds or Maryland is looking to collect the estate tax, they look at everything. They're going to look at joint property. They're going to look at your IRA. They're going to look at your 401k. They're going to look at even your life insurance, which is not doesn't go through probate. They're going to look at everything in your estate. So it's not just the probate assets that are counted in that $13 million figure or that $5 million figure. It's everything. Now the Maryland estate tax, the federal estate tax rate is huge. It's in the 40. I think it's something like 43% or whatever. Again, I mean, now over 30. Maryland, it's a much lower rate. Yeah, I think it starts out at 9% and goes up to a maximum. You know, if you got $10 million, it's 16%. It's a graduated, so it's not as heavy in tax. Yeah.
So is the 5 million in Maryland, is that the individual or joint total?
That's for an individual. So if you left it, we used to do these complicated bypass trusts. You don't have to do those anymore because the law changed on that. But I guess the best way to think of it is if a married couple had $10 million in assets, they would not have. It would pass through without a statement.
How does the home held by a couple when one dies, how does that factor in the tax calculation?
Well, they're going to appraise it. See, it doesn't really make any difference if it's a married couple, because essentially they take half the value in the husband's estate, and then the wife's estate they don't have. It really doesn't make that much difference if you're combining the two to get a $10 million threshold. But for example, if it was a couple that was not married who held the property jointly, they would, unless there's some other showing, they would sort of take half the value of the property.
But when one spouse dies, the surviving spouse inherits the $5 million essentially threshold as well. They
Yeah,
get their
I mean, you have to-
spouses.
Yeah, you have to be careful with that. You really should file a return. I mean, the recommendation is if you're in that area, is to file a return, an estate tax return, even though you're not responsible for the tax. That way you can show that the husband, let's say, passed on $4 million to the wife on this date, 1999, and then when the wife dies in 2023, she gets, that's not included in her total for the $5 million. So they're exempting the spousal transfer. But you know, the best way to do that is to file a return, because then you can show the state, I told you back in 1999 that my husband passed on to me this amount. Here it is right in your records.
So, in determining what the size of the estate is for state tax purposes, and let's use it, let's assume the exemption falls, notwithstanding or look to the contrary, back to what it was before the big jump, which I think was $5 or $6 million federally. So you have an estate that's over the exemption, both Maryland and federal, by $3 million. But you give $3 million to a series of charities. Is that $3 million subject to the estate tax?
No, in other words, when filing an estate tax return, there are certain deductions you can make. For example, you make the cost of probate. You might make. You deduct that inheritance taxes that has to be paid on. So, among the deductions that you can take for federal estate tax purposes would be charitable deductions. So, some person who had, let's say, it was $1 million over the threshold, and that person had $1 million to charity, is all of a sudden under the threshold.
Right.
Or after that. Again, that's probably Will's 102, but and then there are some things you can do, not a whole lot anymore. There are some things you can do to, I don't want to say avoid, but to limit the federal state tax. But again, that's the subject for another thing. Family partnerships and so on and so forth. Most of it has to do with valuation. Okay.
One more question, when you're dealing with life insurance proceeds, do those proceeds, are they treated as part of, if you've named a spouse and not the trust or estate of the individual, they would get treated as the assets of the surviving spouse, correct?
Yes, for federal state tax. Yeah. You mean, so when the wife dies?
No, yeah, if
It's like when the second spouse dies.
No, when the first spouse dies, they need the other spouse basically $1 million.
Okay, no, well, that depends on who owns the policy.
Correct.
Let's say the husband dies and he owned a policy, a $1 million policy went on to his wife. That $1 million would be treated as part of his estate tax for estate tax, for estate tax purposes. So if that was within the exemption, she could use the entire exemption, so it would not be taxable to her estate. And it would be, they look at who owns the policy. That's, if you own a policy on death, then that's your asset. Not who the beneficiaries, but who owns the policy. Okay. Bequests from estates, transfers on death are not subject to income tax. So some people, say, "Oh, we're not now. It's December. We're going to distribute the estate." And I said, "Well, can you wait till January? I don't want to." And that's not meaningless because you're not paying income taxes. Somebody who receives money from an estate does not pay income taxes. It's tax free. It's not considered income, and that would include like a joint account if you're a beneficiary on a joint account. It goes to you. It's not income to you. Okay. of course, if then you have the money and you earn interest, then you're gonna pay money on the interest, but is a transfer on death is not subject to income. Some states like Maryland, I guess sort of to make up for the fact that it's not income taxable, have an inheritance tax. DC no longer has one, Virginia does not have one, I think New Jersey and Pennsylvania have them, but Maryland has a 10% inheritance tax, which essentially replaces the income tax, because they're not, you don't pay income tax on money on it. So 10% in, and Ms. Lee, I think you asked me about the estate tax is applied to the whole value of the estate. Inheritance tax is payable by the recipient of the money, or the residents, or whatever it might be. So the best way to think of it is, it sort of replaces the income tax. The good news in Maryland is that it doesn't apply essentially to family members. It doesn't apply to any inheritance by spouse, parents, children, grandchildren, cousins. It does apply to, but it does not to the immediate family. So there's no inheritance tax. If you leave money to the guy down the street, then he pays a 10% inheritance. Now, Maryland, in theory, collects it on joint accounts as well. So if you had a joint account with the guy down the street, and it was $20,000 in that joint account when you died, and transferred it in on death, Maryland would want to collect an inheritance tax on half of that, $10,000. But frankly, it's most people don't report it, so it's hard to collect that. I mean, there is an information report required, but whatever. But it's taxable, yeah.
Simply spent a lot of time dealing with Maryland issues.
Yeah.
Domicile, what's the strict definition of Maryland domicile?
Well, which way you intend, what your intent is. So,
You're dead, so how do they know you're dead?
so they derive your intent. So, I mean, they look at stuff like, I just had a case where there was a dispute over whether Florida or Maryland. You know, driver's license, voting. Where you live is where you, how many nights you stay is a consideration, but not the sole consideration. Driver's license, like I said, voting. They even look at stuff like who your doctors, where do you go to your doctors? So it's a complicated issue that becomes disputed, and it may be disputed by the feds or the state. You know, who, more likely the state, like Maryland. And Maryland has an estate tax. Florida doesn't. The family of the deceased person is going to say, well, he was domiciled in Florida. They don't, in Florida doesn't have a state tax. Maryland's going to say, wait a minute, he was domiciled here. Yeah, he voted here, he had a driver's license here, you know, had a residence here. He just had that condo in Florida he went to for a couple of months. So that's the type of dispute you get into. So if you were concerned about that, I'd talk to a lawyer. I think probably in both states, got to nail that down. But I can't give you one answer. I mean, you think about it. If you really want to be considered a resident of, say, of Florida, I'd get a driver's license there. I'd vote there. Starters.
We move around the planet. I mean, we pay taxes.
You know, where you find your tax returns, state, you know, that's important. Of course, you could change every time. In the case I had, the guy moved to Florida in December, and he died the following year. He moved from Maryland. But he had filed, he filed a 11-month tax return in Maryland, meaning that he had in fact moved to Florida. That was helpful, yeah.
We have another question from Zoom.
Okay.
If a non-family member receives funds from both a TOD stock account and a bequest from the will, are both subject to the 10% tax?
Yes. Yeah. In Maryland, yes.
I think you're gonna get in trouble with the bar association by giving yes and no answers. You have to.
You know, I'm giving you the answer that the register wills would give you. Probate clause.
We also want to get into directives.
Okay.
Okay.
Okay. And, you know, internet wills, I get a question about this. You know, people get wills off the internet, legal Zoom and all that stuff. They may be okay. I think it's best, even if you do that, that get a little half-hour consultation with a lawyer to have a look at it or her look at it. The problem, as I say here, they cannot be, you know, familiar with a particular family situation. And then there's a robot there, and that robot doesn't know all the ins and outs. They're not going to sit down and talk to you about things. So, you know, they're good in a pinch, but if you're going to go that route, I'd certainly have a lawyer take a look at it. Okay, that's my feeling. Quickly, the probate process. Personal representative files the original will, a death certificate, and some other, you know, paperwork that the court has with the Office of Register of Wills that's located in the courthouse in Rockville or Upper Marlboro, if you did in Prince George's County, in DC, you know, at the courthouse in DC. Personal representative in 90 days files an inventory of the decedent's property. She had a bank account in this bank, and there was $100,000. She had a house on Tuckerman Road, and it's worth $850,000, and so on. You know, this the value of all the assets. Creditors have usually 6 months to file claims against the estate. A little notice is published in a local newspaper, and the creditors have to file claims within 6 months, or they're barred. After approximately, and this is about what the going rate now. After 10 months, if the debts are paid and other legal matters resolved, as assets are distributed, and the estate is closed. So that's about the time period. Now, look, if you got somebody fighting over the will, or the kids are fighting and that stuff, or there's some drawn out dispute with the creditor about money that was owed, then it's going to take long. But you can usually wrap it up within a year. It's sort of in Maryland. They're pretty efficient. Avoiding probate, as I say here, probate is not that difficult process in Maryland, but sometimes there's compelling desire to avoid it. People have bad experiences, so on. Joint accounts and payable and death accounts, which we discussed earlier, are the most common ways to avoid probate. Well, husband and wife have everything jointly. Then there's no probate for the first spouse who dies. So that's a perfect example. So some people, be careful if you're doing this and you have children. You know, this is a situation I confront. Let's say a widow has 3 children, and she has several bank accounts, stock accounts. For convenience, she puts daughter A on the accounts. She dies. That is daughter A's money. It doesn't have to go to daughter B and daughter C, because she put daughter A on the joint account. She has no estate. The daughter B and daughter C get nothing. I mean, daughter A might like her sisters and share it with them, but she doesn't have to. So you want to be careful if that's your sole estate plan. Maybe you have daughter A on one account, daughter B on other, daughter C on another. I don't know. You do something like that. That's the caution. Revocable trust law. These are very popular. This involves placing your assets in the trust while you are living. A successor trustee distributes your assets when you die. They're not for everyone, but are popular among most estate planners. People put their house in the trust, bank accounts in the trust, and they avoid the probate process. Okay, but you know, again, we won't go into all the details of that, but that is a very probably the most popular way these days of avoiding probate. Okay, there's some restriction on that. But then you're not going to be able to put your IRA in the trust. You know, you want to make it designated beneficiary of that. Some people don't like the irrevocable trust because if they want to go refinance their house, it's more difficult to do so. And so on, or, well, whatever. Something to consider, but you're obviously going to talk to a lawyer about the do's and don'ts of that. Minor disabled children, special planning is important if you're a minor or disabled adult child. Typically, you will nominate guardians, trustees for minor children in your will. We discussed that before. For a disabled child, you may want to establish a special type of trust in your will or even while you're living. There's what we call a special needs trust and supplemental needs trust, where essentially a trustee is expending money for that disabled child. A supplemental needs trust is important if your child, adult child, is getting some sort of state funding or state housing. Because if they have just a regular trust or even a special needs trust, the state's going to say, well, you don't need the housing or you don't need the, the benefits, etc. So you want what we call a supplemental needs trust. I'm not going to, if you're interested, I can show you copies of those, but we won't get into the details of that. But be careful is all I'm saying if you have a disabled child as to what type of trust you establish, and whether that child is, eligible for receiving state benefits. So, okay. Okay. Other documents. When people do wills, they may do a trust, as we talked about. The two other documents that we typically talk about. One is a power of attorney, which has here, Maryland has a statutory form for power of attorney, which is comprehensive, and these must be done right. Power of attorneys are valid while one is still alive, and they terminate on death. Purpose is to have an agent act for you when you are unable to do so, including while you're disabled. This may mean banking, paying bills, writing checks, filing tax returns. A spouse or trusted child or family member is usually named as the agent in the power of attorney. So, particularly elderly persons would but of course you want to think about it before you're at that point, you know what I mean? You have it there. Use the Maryland statutory form. If you don't, the bank's going to give you trouble. You can actually get these off the internet, but you might want a lawyer to explain all the specifics of the power of attorney. These must be notarized. Yes.
At what point would a power of attorney be instituted? Can you say at
see,
what time, at what point does
this is interesting.
get executed?
You can do it. You can make it effective immediately. Spouses usually do that. When the spouse, each spouse will sign a power of attorney and make it effective immediately, because the husband's on a business trip in California and the wife doesn't. So they do it right away. But with let's say a person with children or whatever, they probably want it to kick in when they become disabled. And you can put that language in the power of attorney that it becomes effective upon my disability. Now, you can define what disabled means. I like to simply say when my attending physician certifies that I'm disabled. Some people have where they want two physicians, and that really gets fairly cumbersome. I mean, if you got a trusted, if the person who's doing your power of attorney, a child, or your husband, they're well-meaning anyway. So why make them go through all a bunch of hoops? But some people, want to do what you want. Yeah.
I was gonna say, I went through this just recently with my own parents, and I can tell you that most of the powers of attorney, standard form powers of attorney in most states, I'm dealing with West Virginia, the banks will not accept them at face value because they oftentimes don't include a full harmless clause for the bank. And so you end up giving it to them, they look at it and say, it's nice, but it doesn't include this one little clause. And
That's
so
interesting.
you end up having, they take it, and they end up just giving you their own
Yeah, I know.
bank specific.
If that's ideal. If you go to the bank, they give you theirs, fine, because then they can't argue with it if you sign theirs. Yeah.
Right, and I encourage people to do that,
Yeah.
but otherwise it's.
Yeah, and I usually tell people now, which I think capital, I don't know, but whatever. Most of the banks in Maryland will take that Maryland notary form, because the law says that if they accept it in good faith, then they're held harmless. They don't have that. Okay,
Would a
yeah,
bank power of attorney be applicable everywhere?
no, because it's going to be specific to that bank. So you better get the power of attorney also. The other form is advanced care directive, which is called living will. This appoints an agent. Unlike the power of attorney, which is mostly for financial matters, this is for medical matters. You appoint an agent, talk to doctors, you're unable to do so. The Maryland form is a two-part form. The second part deals with end-of-life decisions. At what point do we stop extraordinary medical intervention and so on? That form is available online in Maryland. Hey, the best place to get it is if you go to the Maryland Attorney General's home page, the website, and right on the front page is the thing, Advanced Directive. You click that out and it's there. But you may want a lawyer to explain that to you.
Question over there, Terry.
Yeah.
Wasn't a question. I was just gonna say, it's really important to know that power of attorney does terminate on the, it's not gonna do a
Only
situation.
if a person dies, that power of attorney is no good, because it goes back to the law of principal and agent. And when your principal dies, the agent has no authority, and that's what that is. So you can't say, well, it's okay, I'm my mother's power of attorney, I can still write it. No, you can't, because then the will takes over.
Then you're liable for that, whatever you did.
So, it's no good on that. Yes.
The power of attorney situation gets complicated in practice. My sister just appointed me as her power of attorney, executor. We've gotten it all straight because she messed up the will by going through it.
Your sister's still living. She's still living now.
She's still.
Yeah.
So what I'm about ready to explain is that, having a power of attorney, you gotta think practically, what do you do with it? Or what do you have to do with it in case they become incapable of taking care of themselves? And if you don't live in the same state with them, how do you deal with the funds? How do you deal? What do you know, what are her assets? I have to make her sit down and give me all of her assets. Because my fear is she's older than me, that may not, it's either physical competency or mental competency. One's gonna go first. And I needed to know what the assets were. We had to have the frank conversation. What do you have? Where is it? What's the account number? Now she's giving me a copy of her taxes, so I at least have a tax statement, so I can have, information on it, what she has to there, everything for what few accounts she has. And it's important that while they are capable, have that conversation about their wishes.
Yep.
What are their wishes? If your health fails, you want to go to a Baptist, let's keep the things you want to go to Baptist, what is your interest here? Think about where you would want to be and let's have this conversation. It was a very painful conversation. But she's so glad she had it, because now she can achieve, and now has gone and gotten her own funeral arrangements.
That's always a good idea.
And she's my mother did that for us. It was the biggest gift she could have given. It was a blessing, but now she's pleased she got through it, but not everybody can be. It's not an easy conversation to go through, get all the way through all of the entanglements of this conversation beyond just finding the power of the fingers.
Okay, very good point. Yes.
We've got a couple more from.
Okay, and when we do this, we're gonna have this sort of mock interview, but it's, give it 2 questions first.
First from Stephanie, is it really a big deal to have your durable or health power of attorney a beneficiary of the estate?
It really doesn't make any difference. Really doesn't make any difference. I mean, it usually is because you're usually selecting a family member, you know, an older person would select a daughter or son or something, but it really is an unrelated family.
And then this looks like more of an observation than a question, but from Susan, we found that no doctor would state disability. And there's a time gap between death and appointment of personal
There
representative.
it is. And I don't know what to tell people about that, there is. It's gonna take a few weeks to set up that estate. So, you know, a lot of times with the personal representative, I can pay them for the funeral, you know, the personal representative might put it on their credit card and then have to be reimbursed later. So on, so that's an issue. I don't have any good answer to that. Yeah, except to be prepared for it. You know, people have a person who's, you know, let's say going downhill or they're in hospice care, might want to transfer money to their personal representative while they're living, so that they would have that ability to pay immediate bills before the estate's established. Okay.
So, we thought we might try to take some of these ideas we heard about today and plug it into at least a preliminary discussion with an attorney about a will and other trust documents. So our situation was that we retained Tom to assist with the will after having one in place, and it was no longer appropriate because our children are now adults, and the provisions dealing with a guardian for the kids changed, our asset picture had changed. And so we sat down with him. And so this is not the first will, it's the first meetings with the new attorney about the situation.
Nice to meet you.
Nice to
Nice
meet
to
you.
meet you.
One nice thing, Tom came to our house, so I always say, thanks for coming by, Tom.
It was easier to park.
Easier. We didn't charge him, because it would have turned up until afterward. Tom, what did we tell you about our family and our situation and objectives?
So, you know, I'd like to find out how many children you have, whether they're adult children, their ages, whether they live locally or outside of town. Essentially, do any of the children have special needs, or you know, sometimes I get situations where some families have a son or daughter who's, you know, a movie star, and that they have a lot of money, and the others 2 or 3 children are, you know, ministers of the church or something, and not making that much money. So whatever. So differences in the children's needs. I ask people about charitable bequests, if they have any favorite charities, if they like to provide for those charities. I would ask people about to get an asset picture. I mean, I don't need to know, you know, what your stock account closed at 4 o'clock on Friday afternoon. You know, I don't need to know the running total, but, you know, an approximation of what the assets are, and, you know, the nature of the asset, real estate account and so on. And then I ask them about such things as retirement accounts, joint accounts. So that's really the basic information. But each family is going to have some details. Yeah.
In our case, we have 3 grown children, 2 were married and no children. And we would like to divide our estate equally among the 3 of them. Plus, that we'd like for them to get a 4th. And then the other 4th, some will go to our Bulgarian daughter, Vietnam, and the rest will go to St. John's, Suburban, and girls on the mother.
Okay.
To
So, you know, with charitable bequest, you can leave, you know, a specific amount of money, or you can leave a percentage of your estate. So in other words, that you to St. John's Church, you could leave $50,000, or you could leave 1/8 of your estate. And so I don't, whichever you prefer, you don't know exactly what 1/8 of your estate will constitute, but you may have some general idea. So you make that determination as to whether you want to leave a specific amount, or whether you want to make it part of the residual estate, and leave a percentage.
How do you estimate? Wait.
You talk to an accountant, maybe, I don't know. You know, of course, that's, of course, it's based on your age, your health, your the nature of your assets, and so on and so forth. So, and it's also, recall that you can always amend your will. So if 5 years down the road, you determine that 50,000 you were going to leave to the church should now be 100 or 25, as the case may be, then you amend your estate. Or if you decide that the 1/8 that you were going to leave to the church now should be 1/10 or 1/4 or whatever, then you make that. So in that particular case, that's something you want to keep an eye on and amend from time to time.
What if you were to say, take your numbers, it could be 1/8 or it could be 50,000. So what if you say 1/8, but up to X dollar figure?
Okay.
So the real worry is the other one. What if our assets decline? Our goal is to fritter away as much of our assets as possible
Right.
before the kids get them.
Right.
That's this being recorded. So
But they have to have the password to get in.
so, good point, lawyer's advice. So the question I had was, what if the figures fell? So we were not going to be able to give the children all we wanted to, and yet. So that's the idea of
Yeah, you can do
1/8
that.
or 50 or.
Yeah, that makes sense. In other words, they have a cap on the 1/8, whatever the amount might be, or a low level.
It's just an option.
Yeah.
I think when you're dealing with a guardian for the kids, which is not an issue we have right now, but well, it's the way it is. Why don't you pick up on that?
Our children, I have children.
Yes.
Right?
Well, that's a good point, because you mentioned you were going to leave your property in some respects, equal shares to your children. Heaven forbid, what happens if one of your children should predecease you? This is a very difficult question, because some people say, well, okay, then whatever happens, whatever their will says, or whatever. But do you really? Very difficult question. You wanted to go to the daughter-in-law, or do you want it to go to the children? So some people will say, well, maybe I don't want to go to the daughter-in-law. I want it to be in trust for the grandchildren. So you could do that. I leave 1/3 of my estate to my son, John. If John shall predecease me, that his 1/3 share shall pass in trust to his children. Probably name them, or, since he might have more, I usually say, or any other children that he might have. You don't want to leave out a child that gets born next year, so you want to make sure that you want to include that. And so then you would have, what often will happen in that case is you could name a trustee for those grandchildren, and it might be your other son, or the uncle or the aunt of the children. So this is something you have to consider. What happens if it doesn't happen often, but it does happen that your children predecease you. And of course, you can amend your will if that happens, but things happen quickly sometimes. There's a pandemic, the son dies, the mother dies, so something to consider when you're making your will originally.
So here's a particular complexity, and that is, in our case, at the end of every calendar year around Christmas time, we give each of our 3 children a gift, a check in a certain amount. I understand that there are gift taxes. I understand that there are implications, so a gift on the exemption amount. What's your advice? What are the limits?
Well, you know, you can give each person can give, I guess it's 16,000 now. It may even have gone up at the first of the year, but let's say it's 16,000. I have to look that up. Which is, does not count against your gift tax exemption. So each year, a husband and wife could give each child $32,000 without any tax implications at all. Or they could give another 16,000 to the minor child of that couple, whatever, you know. So just think of that 16,000. The reason the $16,000 amount arises is because it's rare that you would even pay a gift tax initially. Is that you have a lifetime gift exemption, which is matched with the exemption in the estate tax. So remember, we had on the board a little while earlier that it was that the current exemption is $13 million. That amount is reduced when you die by gifts you have given during lifetime.
Regardless of the amount.
I should amend that. Gifts over 16,000 per person per year. So if you, let's say you gave a son 17,000 in 1 year. 60,000 you don't have to worry about. When you die, they're going to take $1,000 off of that 13 million for your exemption. Now that doesn't seem like, but if you give your sons, this happened with Jack Kent Cook, the guy who owned the Redskins, and then remember the sons had to sell to Snyder because they couldn't pay the estate tax because he had given them gifts all along, and he didn't have any exemption left on his estate tax. So you have to watch that. But you know, interfamily gifts like that, 60,000 a year, you know, we've got it all. I'll take one. That's what what's over here.
You must have given me a lot then.
The estate tax is over.
So the reason why we're doing this, just for your information, is we think the money given now is going to be more valuable to them in their lives.
Yeah.
With young families, all the cost, than if we wait and give them a lump sum down the road.
Right.
Whenever that might be, God will decide that. It could be a long way down the road. We're hoping. And so this is a way to do it. And we're kind of mindful about the niceties.
By the way, you give your spouse, that doesn't count as gifts, so you can give your spouse whatever you want. And okay, that's not a big issue.
And we've heard of various types of trust for estate purposes. What are the advantages and disadvantages?
So the revocable, yeah, the revocable trust is the most popular, and that's really a probate avoidance plan. It's not a tax. It really doesn't change your tax situation at all, because whatever's in the revocable trust is going to be counted towards your tax exemption when you die. But it takes the asset out of probate. A lot of people do it with real estate because they have the idea that an estate proceeding involving real estate would be complicated. Although in Maryland and DC, it is not anymore. It used to be. But so what it means is if you had a revocable trust, the house, let's say, would be in this trust, and if you were to die, let's say your children who were beneficiaries of the trust could immediately contact a real estate agent and sell the property or rent the property to a tenant, whatever, without going through any probate process.
So it sounds like the main benefit is you avoid that 10-month lag.
Yes, you do. You do that.
So last question, because I think you've answered some of the other ones we came with.
Well, but I had one more. Are there any documents which we still need to have in our plan if one or both of us becomes disabled, or we enter the
find this sheet.
Yeah, you want to have a durable financial power of attorney and a advanced healthcare directive, which is also called a living will. So if people will typically do that, it's a good time to do it when you're writing a will. And these are things that can be updated. The advanced healthcare directive, you nominate someone to be your agent. It's typically a spouse, and then you have a backup as a child or children. And from time to time, you might want to update that. You know, one child moves out to California and there's another child locally, so you want to put that person in there as agent. That type of thing happens. But these can be amended fairly easily, but you want to have those down when you have your will. Even a younger person in their 30s and 40s should have those in place. And again, you can amend those later.
And where should those be kept? And what copies be kept?
Under the baloney and the.
Yeah.
If I see was in a copy in the glove compartment of each card.
Really?
And give a copy to the person.
Yeah,
That's the one.
That's what I like to let them, because the person who's got to use the power of attorney, they're the ones that are going to need it. So a copy, at least a copy to them is good. And if they don't have the original, tell them where the original is. Now, some people, they want to sign 3 original power of attorneys, give one of them. That's all right. If you want to do it that way, fine. Yeah.
But I heard a story where a parent signed it, but they didn't want to give it to the copy to the kid.
You know, what is the kid going to do? If you're the agent under power of attorney and you can't run off the money, you're committing a crime if you do. You're embezzling if you do.
Adult kid.
Yeah.
Yeah. So what they have power to give.
And
I've also heard that you can that the fire department and the hospital recommend putting files in a freeze lock container and marking it ICE in case of emergency. And in that you keep a copy of your medications and your living will and power of attorney.
yeah, I've gone to somebody's house and I've seen my name on the refrigerator.
Congratulations.
Yeah. Next to some Mount Rushmore sticker or something. But so that they'll put on there who to contact. So you can do that, or contact this guy or this person, and that person would know where documents are.
Well, I can match that. On one of my planned giving calls, I talked to somebody and she actually heard you and put together a will, and then she told me a few months later that she wanted to adjust the will as far as St. John's was concerned. Could I come by? She gave me the will. All of a sudden, I'm the trustee. We didn't have any conversations at all about that, but I'm now the alternate trustee, thankfully, under the will. So amazing things can happen. Are there any other suggestions that you have?
Here's what I have. I think you should tell your kids what you're doing, because it seems to me a lot of litigation arises because of surprise, anticipation, and so on. But if you explain to your kids, like, Joe is well off, he's got a house and so on and so forth. But Mary is, a special ed teacher, she doesn't have that much. And so you want to give more to Mary than to Joe in your will. That's fine, but I think you should tell Joe that this is what I'm going to do and this is why I'm going to do it while you're living. So that then you don't have that later on. You don't have that, that somebody, if they have anticipation or whatever, the surprise, they get mad, but if you talk to them, explain it to them, then you avoid that. I think that's important.
Well, thank you. This has been amazing. I think you came to our house many years ago. And I was like
fixing your.
Yeah, this is great. Couple questions. So if all the assets are either transferable on that or joint custody of ownership, then you don't even have to go to the courthouse to.
No, but usually you do have to do something. I tell you why. There's always something. If there's a motor vehicle that's not in joint names, or you get a refund from the doctor. You get something that's only got the one person's name on it. In Maryland, fortunately, we have what we call a small estate law. And if the assets are meager, you don't even have to have a lawyer. You go up to the Rockville, you sit down with them, they'll put out all the papers for you. And you can transfer that motor vehicle, transfer that little bank account and so on. So that's called a small estate. And it's actually $50,000 and under now. Now they raise it for a spouse, 100,000 and under. But for non-spouse, 50,000 under. So some things are gonna like not make it in, but fortunately we have the small estate law, so you're gonna have to wait.
The other one is order to be a joint owner and not be liable for the property.
What do you mean liable?
Also, let's say my mom has a property and I want to, hey, if I'm a joint owner now, we can avoid hassle
There's a
later.
problem with that tax reason, but go on. I'll tell you about that in a minute.
What if she skips a mortgage payment? Does that ruin my?
Oh, you're not on the mortgage, but you're gonna lose the house if you don't make a mortgage payment. First of all, always get it insured. If you're a joint owner, make sure the house is insured. And you're one of the people on the insurance policy. You gotta do that. That's where you avoid liability for, somebody falling down on the property and so on. The second thing is, there's a problem, and this is why a lot of people use trust. There's a problem with putting a property, a piece of a residence in a child's name now while you're living. It has to do with the basis. When you sell a piece of property, you potentially have a capital gains tax to pay. Now, normally, there's usually not much because there's a big exemption. It's like $500,000 for a couple. So if they move up, their residence to another residence, they don't have to pay any capital gains. But there's a potential capital gains tax here. But their basis is the cost of when they bought it, plus whatever improvements they made all along. The problem with giving a house, or placing a child's name on the house now, is they get your basis for when you bought the house. So if you bought your house in 1990 for $100,000, and it's now worth $700,000. And you transfer that house, half of that house to the child now, when he or she goes to sell that years from now, their basis is $100,000. And they're gonna have to pay a huge capital gains tax. What happens is when you inherit property, they give you what they call a stepped up basis. It's stepped up to the date of death. So instead of the child having a $100,000 basis, they got $700,000, whatever your house is worth. So that's why you want to wait till death. With the revocable trust, you can do that. They don't get the property until you pass away. You can avoid probate with a revocable trust. I would not put a house. A bank account doesn't matter because it doesn't really have a basis. It's shifted, whatever. So with real estate, I would avoid that joint ownership. There's an exception. If the child actually lives there in the house and that's a child's residence, then they would get the exemption on a capital gain. But so talk to somebody before you do that, is what I'm saying.
Are there any other questions online?
Yes.
What's a reliable source to find a reliable estate attorney?
Well, you Montgomery County, they have you call the Bar Association, and they have a lawyer referral service, and they do it by sections. So in Montgomery County, that's a good way to do it. I mean, it's probably you ask other people who had good experiences with, ask them who they dealt with, so. It used to be, lawyers are very specialized. Now, didn't used to be that. I mean, doctors, especially. You go to a doctor, orthopedic doctor, they got a doctor for the left shoulder and a doctor for the right shoulder and everything. But they have for everything. So lawyers have become a lot more specialized. When I started, most lawyers would do wills and trusts, but it's sort of changed now. But I think that's probably the first place to start, Montgomery County Bar Association, the lawyer referral service. Because they're going to have, and you tell them specifically what type of service they want. And they'll have a list of people in the county to do that. And you can tell them what one Rockville, that's what one Gatenburg. Those.
If there are no other questions, I just wanted to mention something else. One of the things that I become concerned with, having dealt with this issue in a number of different ways over the years, is how the deceased can be kind even after they're deceased to their heirs. And one of the big problems is if you're opaque about where things are, what they are, and that sort of thing, you just made time when your family is in pain very hard for them to come to move through this process, whether it's probate, trust, or the like. So I wanted to call to your attention a couple of things. There's 2 pages that I pulled off the internet a few years ago and circulated a number of meetings. There's some copies over there, getting your affairs in order. And it asks you questions. Where do you want your funeral? Do you have valuable papers that need to be kept? Where are they? What are they? What are bank books, stock certificates, sites, deed of ownership? Have you compiled a list of items? What are they? Some of this is a little dated. I added a footnote saying it. It's on the computer like it is with most of us. What's your password? And put that in a place where they can find it, not to say deposit box. And Kathy and I read around a little bit. What's that? Oh, we rooted around a bit, thanks. And we found the book online, and it's in sold in Hallmark. It has a grisly title. I'm dead. Now what? So that's to get your attention. But what it does is, in the multiple pages within, it goes through such things as the personal contacts, the medical documents that they will need, where things are found, and you have places where you can put all the information, the bank account information, what's the number, what's the branch, that sort of thing, and passwords. And
You know,
passwords.
that reminds me, tell your lawyer in the will to put in a sentence, which I do now. Not that it's always required, but some people will give you problems. I authorize my personal representative to obtain any passwords from any tech company or phone company or whatever. Because sometimes Apple, they used to, I don't know if they still do, they would give you trouble about transferring a phone if you didn't have some clause in your will. That's the only one I know that really said no. Let's give it to the personal representative, but I'd put a clause in.
Lastly, before I turn it over to Kathy for a very short comment about what the next session is if you are interested in talking about your will or request to the church or anything like that, I'm more than happy to talk with anyone. So feel free to call me. The number's in the directory, and so is the email address. The main goal is to make sure that you're doing what you want to do and you've thought it through. Obviously, we'd be delighted to have you as a member of the Norwood Guild, or anyone who has included St. John's in their life insurance policy, their pension, or their will, gets recognized. If you want anonymity, we can provide that too. And that's it for me. What about the next meeting?
On January 22nd, we invite everyone to come and hear from Melanie Volstad and Julie Rashofsky about the financial end of things. When's a good time to start the conversation? What do you need to know? How do you protect yourself against scammers? How do you protect your loved ones against scammers and any type of fraud? So we invite everybody to come back on January 22nd.
Julie's an attorney who has dealt with this calamity in her own family, and how she dealt with it through a person who committed fraud, wiped out her mother's assets. And Melanie is a splendid financial planner, and their goal is to help people think about what they need to do so that they don't end up at 55 saying, we don't have what we need, and we don't know how to get there. So thank you all for being here.
Bye, everyone.
Thanks for the question.
It's